Summary और ये ऑन कर दें. Good evening, friends. Before Christmas, if we could have a Santa Claus giving gifts, there cannot be a better thing. And on the same way, if your holidays are starting as a lawyer, you can't expect much better legal knowledge being shared from a person like P.S. Rajagopal, a senior advocate. And being connected with Vikram, they say it's an icing on the cake. So these all not formal contracts, but a contract to share legal knowledge is what it can be said. Trikram means try. So it's a try understanding between me, Mr. Rajagopal, and Trikram to share some knowledge prior to the Christmas. So we say Merry Christmas prior to that. And the understanding of unconscionable contract of the employment in respect of a famous judgment, not only for the students of law and the employees, employer, and the lawyers itself. Is a fascinating judgment of Central Inland Water Transport Corporation versus Brojonath. The nuances of Section 23 couldn't have been better explained than this judgment. Before we ask Mr. Rajagopal to share his knowledge, we'll ask Vikram to share his few thoughts. They say sometimes the Santa comes prior in time, otherwise normally Vikram comes at the later part of the session. Over to you, Vikram. I think he also has an issue. So you can take over.
Because Trivikram and friends, frankly, I was not ready to, or I was doubtful whether I would be able to spend a time in webinar or invest a time in webinar just before vacation. Luckily, it happened that our High Court was closed today. For us, the vacation started yesterday. Whereas for the rest of the country, including schools and colleges, it starts at the end of today. That is, we had a holiday today. Therefore, when Vikas said, can we do a session on this Friday? I said, yes, because that would be a good year ending for me also. Because ultimately, we should speak something that is close to our hearts at the end of the year, so that we can welcome New Year in a happy mood. Central Inland Water Transport case, corporation case, according to me, is a landmark, both in the matter of contract law as also in the matter of constitution. The simple issue that was involved in the Central Inland Water Transport Corporation was whether a government company can be regarded as an instrumentality of state under Article 12 of the Constitution. Second question was, the second and most important question in Central Inland Water Transport case was whether naked hire and fire policy would fall foul of constitutional values if it is practiced in a contract of employment by a government company. Yes, before Brojonath Ganguly also, there were 3 judgments. One of Karnataka High Court, which I have not been able to trace in spite of my best efforts, rendered in early 1980s by my Lord Justice Rama Joyce, who in respect of a government company, that is Bharat Electronics Limited, had held that a clause in the service contract, which enables the employer to terminate the services of a permanent employee with 3 months notice or 1 month notice or whatever it is, or notice period salary in lieu of notice, is bad in law and it is unconstitutional. That was the only judgment regarding a government company. And I have, with the best of my efforts, I have not been able to trace it because it is not a reported judgment. I hope to get the assistance of my good friend, Mr. Trivikram, to somehow trace it because it is a treasure. Because that would be the first judgment which would have applied the concept of Article 14 to a government company. That was one judgment which I have not been able to trace from Karnataka High Court. There were 3 other judgments rendered by 2 high courts. One was the judgment of Lordship Justice P.B. Sawant as single judge of Bombay High Court, where accepting challenge to Regulation 48 of the Service Discipline and Appeal Regulations of Air India Statutory Corporation, which was a statutory body established under Aircraft Act, that clause 48, which enables the employer to terminate the services of an employee as no longer required without assigning any reason, Justice Sawant had held it to be bad. But at the same time, there was another division bench judgment of Bombay High Court, where dealing with very same regulation of very same Air India Statutory Corporation, division bench had held that such a clause is valid. And then the judgment of division bench of Calcutta High Court, rendered by Lordship Justice M.M. Dutt, as it then was, holding that such a clause in the Central Inland Water Transport Corporation service regulations, the service rules, is bad in law. They therefore effectively, while the Air India was a statutory corporation, in respect of government companies, there were only 2 judgments that were available. One is the judgment of division bench of Calcutta High Court, from which the appeal arose in Central Inland Water Transport case, and another unreported judgment of Karnataka High Court. All the earlier judgments, including judgment of Supreme Court in West Bengal State Electricity Board, that is Deshbandhu Ghosh, though the 3-judge bench of Supreme Court had held that such a clause in a statutory body's service regulations is bad, there was no judgment of the Supreme Court in regard to the government company being a state and the naked hire and fire policy as contained in the regulation in question was unconstitutional. Therefore, I would regard Brajanath Ganguly, authored by Justice D.P. Madan, as a pathfinder. In jurisprudence, we have precedents, but not great value for future. And the second and higher class of contribution to law is pathfinding judgments. Rajanath Ganguly is one pathfinder. The division bench of Calcutta High Court had held that the clause which enabled the corporation to terminate the services of a permanent employee with 3 months notice or notice pay in lieu of notice is violative of Article 14. And in one paragraph, it had also held that it is a state, because only if it is a state, Article 14 can be enforced. But the beauty of Rajanath Ganguly is that the bench formulated 2 questions. One is, even if it is not a statutory body, whether a government company, as defined under the Companies Act, whether it can be held to be an instrumentality of state. Once it is held to be instrumentality of state, application of Article 14 is a matter of fact, because for every state act, in any state action, by then already the Ramana Dayal Initiative was there, which said even in contractual field, the state has to act in accordance with Article 14. The second and more important question that was framed by the bench was whether a contract of employment can be set aside or declared unenforceable if it is contrary to Section 23 of the Contract Act. That is, a contract which is opposite to public policy. The idea was, as I decipher when I read the judgment in its entirety, to ensure that the larger corporate bodies having huge economic power, they do not exploit a helpless worker. He may be even a manager or a senior manager, irrespective of the status. Irrespective of the status, the financial capability of an employee would be insignificant when you compare it with the financial resources to which the employer can lay hands. Therefore, the first and foremost importance of Rajanath Ganguly is, in applying Contract Act, Section 23 of Contract Act, to a service contract, and say that if it is opposite to public policy, then the contract would be void, or that clause of the contract would be void. Another difficulty that was faced by the bench in Rajanath Ganguly was, there was a previous judgment of the Supreme Court in Praga Tools, where Supreme Court, even after noticing that in Praga Tools, 56% of the share capital is held by the government, it has declined to issue a writ, and it had declined to hold it to be an instrumentality of state. Statutory bodies, they stand on a different footing, like ONGC, LIC, or any other statutory bodies. That was in Sukhdev Singh, the position of statutory corporations established under a statute had been clear. But in so far as government company is concerned, there was a contradictory judgment in Praga Tools that had to be overcome. Then these 2 difficulties, that is, whether a government company can be termed as an instrumentality under Article 12. Number 2, even if it is not so, can an unconscionable term in a contract of employment? What is unconscionable? Unconscionable is something that is repulsive to the values of distinguishing between right and the wrong. That is, if something tells your conscience, look, this is the wrong thing, or this is opposed to the right thing. That is, when your conscience is pricked. Of course, it is another matter. Some judges' conscience will never get pricked. Even for that, an answer is there in Brojanath Gangu. Therefore, these two questions independently answered in Brojanath Gangu. On first question, whether it is an instrumentality of state or not, the argument advanced was, see, it is not established under any statute. It is only registered under the Companies Act. There is no judgment law to hold that it is an instrumentality of the state. That was overcome or answered by the Supreme Court by saying that, look, the entire share capital is owned by the government. All the directors are appointed by the government. Managing director of the company is appointed by the government. It functions as a alter ego of the government and discharges government function. Then there was another hurdle, namely, look, if you take Air India Statutory Corporation, it was the act under which the Air India Corporation was established. It conferred monopoly on Air India International Company. Then ONGC, it had conferred government-blessed monopoly on ONGC. Then Life Insurance Corporation of India. No other company other than the Life Insurance Company of India, Life Insurance Corporation, could undertake the business of life insurance. This difference, that is, Central Inland Water Transport Corporation not enjoying monopoly in the area of its operations, unlike LIC, unlike ONGC, that was also put up by the management, saying that government has not conferred any monopoly on us. Therefore, we are not an instrumentality of state. All these were answered by Lordship Justice Madan by saying that corporation established by statutes have been held to be instrumentalities and agencies of government in a long catenary of decisions of this court. For the purpose of Article 12, one must necessarily see through the corporate veil to ascertain whether behind that veil is the face of an instrumentality or agency of the government. The corporation, which is the appellant in these two appeals before us, squarely falls within these observations, and it also satisfies the various tests which have been laid down, merely because it has so far not the monopoly of inland water transportation is not sufficient to divest it of its character of an instrumentality of the state. It is nothing but the government operating behind a corporate will, carrying out governmental activity and a governmental function of vital public importance. this functionality test was propounded, and it also said that not enjoying monopoly in the chosen field is not decisive of whether a company or corporation is the instrumentality of state or not. Then when the Supreme Court tried to or came to examine the question of validity of Rule 9(1) of that is the rule that was under challenge. It came up, it faced a very strange and what the Supreme Court called as an argument which if accepted would result in putting the clock back by a few centuries. That is, Clause 9(1) of the rule in force in the Central Indian Water Transport Corporation stated that the management can terminate the services of any employee by giving 3 months notice. Then there was a corresponding clause which gave the same right to the employee also. An employee can resign from the services of the corporation by giving 3 months notice. Now, if you take equality, what is equality? Management has a right to terminate the services of a person by giving him 3 months notice. At the same time, the employee is also having a right to put an end to his employment by giving a 3 months notice. Both are equal. This was the equality propounded by the management before the Supreme Court. It said, you cannot hold Clause 9(1) of our service rules to be bad because equal right is given to both the management as also to the employee. If management wants to send out, it can send out 3 months notice. If employee wants to walk out, he can walk out 3 months notice. Therefore, it is perfectly equal and the rights and obligations are mutual and identical. To overcome that, Justice Modern, in fact, gave a very, very striking example of equality. In a forest, there will be lion and the lamb. Both are free to roam around wherever they want in the forest. Both of them are free to eat whatever they want to eat in the forest. The only difficulty is only lion has the capacity to devour the lamb, and lamb does not have that capacity. That is where the concept of unequal bargaining power was brought into focus. Now, the main principal argument, there were two employees who had been terminated like that. Both of them were in managerial care. The argument of the management was, look, with their eyes and ears wide open, they have signed this contract of employment. Today, it is not open to them to say that this clause in the contract of service is bad. The answer was, unequal bargaining power is a good ground to set aside an unequal and unfair contract. This is where the judgment in Rajagopal Ganguly stands out. Till then, the firm belief was, in service jurisprudence, no new right can be created. The courts can only protect the status quo. If there is a term in contract of service, that is final. It cannot be interfered by invoking the provisions of public policy or constitutional ideals that are enshrined in directive principles of state policy and fundamental rights. Of course, on Article 14, some discussion had been there, but no contract in a statutory service regulation, like West Bengal State Electricity Board. It is a statutory service regulation. Or in Air India Corporation, it is a statutory service regulation. In a statutory body, there can be a pure contract also. Like number of cases we have seen where the employer would not have framed any regulations, though the employer is empowered to frame regulations. On the other hand, the service conditions would be governed by non-statutory rules or non-statutory contracts. Even where it is a non-statutory contract, this judgment propounded that if it is contrary to public policy, then that clause, which is contrary to public policy, can be struck down. Then the question came, what is public policy? Because whether it is dependent on the government policy or whether it is something more than government policy. Then Supreme Court, going by fundamental rights and the directive principles of state policy and preamble to the Constitution, which has promised certain things to every Indian, it held that the public policy is not mere policy of the government, but public policy is something more. And then it said that the public policy means common good of vast majority of the population. And to drive home this point, it said several statutory authorities have a clause similar to Rule 9(1) in their contracts of employment. As appears from the decided cases, West Bengal State Electricity Board and Air India International have it. Several government companies, apart from the corporation, must be, which is the first appellant before us, must be having it. There are 970 government companies with paid-up capital of 16,415 crores, as stated in the written argument submitted on behalf of the Union of India. The government and its agencies and instrumentalities constitute the largest employer in the country. A clause such as Rule 9(1) in contract of employment affecting large sections of the public is harmful and injurious to the public interest. Smokers, excuse me, it is not harmful to the smoker health. It is injurious to public interest, for it tends to create a sense of insecurity in the minds of those to whom it applies. Consequently, it is against public good. Therefore, anything against public interest, anything against public good was held to be opposite to public policy. Thereby, bringing this clause as falling foul of Section 23 of the Contract Act. Now, what is the Section 23 of the Contract Act? Section 23 of the Contract Act states what are the considerations and objects which are lawful and what are not. The consideration or object of an agreement is lawful unless it is forbidden by law, or is of such a nature that it permitted it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral, or opposite to public policy. This entire clause 9(1) was upturned on the ground of the public policy. Then there are certain very interesting, I would say, lessons for the court also in the Rajanath Ganguly's case. One thing it said was that the validity of Rule 9(1) would have to be tested on the principle of law of contracts. This is very important because testing the validity of the clause on principles of Contract Act would mean that the law declared on such testing of the clause in contract of employment by applying Contract Act would be applicable to all employments, irrespective of whether they are government owned, government controlled, or pure and simple private. Well, there is a clause in the specific fact section which says non-enforceability of contract of employment. But holding a clause to be contrary to section 23 would result in commensurate increase in compensation that one may get even under private employment for wrongful termination of contract of employment. That is the significance of that. And then it also said, one glorious thing it did was, which is almost a guideline for the future, is the naked hire and fire principle contained in termination clause, which said that anybody without any reason can be terminated, is that it amounts to Henry VIII clause. And it said that no other phrase is more apt than calling it a Henry VIII clause. What is Henry VIII clause? King is supreme. King is above the legislature. What the legislature has done, king can undo. That is, power is delegated to the king to undo any provision of a legislative edict. An act is passed by the parliament. King can undo it. That is called as a power delegated to a delegatee to annul the parent act. Parliament makes an enactment, and last clause says, if there is any difficulty in implementing this act, king can amend the act. We have seen removal of difficulties clauses in almost every enact. Because the parliament or legislature, when it enacts a law, it may not know exactly what are the most minute details that would have to be encountered while implementing this enact. Therefore, power to remove difficulties is incorporated there, that within a particular period, during first 1 year or 2 years of operation of the enactment, the government can remove those difficulties. Removing the difficulty is different from removing the law itself. Henry VIII clause is one which enables the delegatee to remove the law itself. Therefore, the Supreme Court termed this clause, which enabled termination of an employment of a permanent employee with 3 months' notice, as nothing short of Henry VIII clause. Or, to put it differently, it is a lawless law. Laws are made, but without any enforceability because of the clauses like these Henry VIII clauses. The Another forward-looking observation in the judgment in Projanath Ganguly is, well, whether this striking down a contract or a clause in a contract, whether it can apply to commercial contracts. Because normally in commercial contracts, what happens is the parties to the contract would be more or less of equal strength. When two traders enter into an agreement, it cannot be said that they were of unequal bargaining strength, as it happens between an employer and employee. Government, the employer can say, yes, if you don't sign this contract, I don't want you. Whereas employee cannot say that if you insist on for this clause, I don't want employment, because for him, employment is a question of survival. For the employer, there is one employee not willing to join does not make any difference to him. But at the same time, if every one-sided clause is liable to be struck down as opposed to public policy, then it may affect the very trade and commerce in the country. Therefore, Supreme Court said, this principle of unequal bargaining power may not be applicable to commercial contracts. At the same time, it also provided for an exception. What is that exception? As a policyholder, when you go to buy an insurance policy, maybe health policy or motor vehicle policy or life policy, the insurer gives you a printed format, that is a contract which is formulated by him, with you having no required to the dotted line. In what way it is different between a contract between an employer and employee of unequal bargaining power? This principle was also enunciated. That is, when a person exploits the distressed situation, inexperience, lack of judgmental ability, or grave will of weakness to obtain grant or promise of pecuniary advantages. In such case, the so-called printed contracts, the obnoxious clause in such contracts can be declared to be opposite to public policy or a unjust, unfair contract. Ultimately, it said any contract taking totality of circumstances into account, if it is unjust or unfair or one-sided, it can be annulled. This principle has been extended by the Supreme Court. Subsequently, in respect of the insurance contracts also, and this is what is that settlement clause? That is normally when we submit a claim under any insurance policy, we have to sign a receipt even before we receive any money. I state that I have received money in full and final settlement. That is accord and satisfaction. That normally it is called as accord and satisfaction. This accord and satisfaction clause was in one of the judgments of the Supreme Court held to be opposite to public policy, applying the principles of Rajagopal Ganguly. Therefore, this judgment has shown the path as to two things. One is, even in a pure and simple contractual matter, unequal bargaining power, unconscionable term in the contract, printed contract, and exception to liability clauses, which are predetermined by the powerful partner of the two, those can be annulled if in the overall context, the contract appears to be unfair and unjust, or would shock the conscience of the court. The second thing is, it said, because one argument that was advanced was there is no precedent where a government company has been government company, particularly when it has not been conferred conferred a government conferred monopoly. There is no precedent where such a body has been declared to be an instrumentality of the state. On that, the Supreme Court very categorically said that the absence or lack of a precedent should not render us helpless. The court has to look forward and not be happy with the status quo. They very interesting that paragraph 66 of the report. The fallacy lies in the assumption which that submission makes that merely because a point has not fallen for a decision by the court, it should therefore be not decided at any time. Were this assumption true, the law would have remained static and would have never advanced. The whole process of judicial interpretation lies in extending or applying, by analogy, the ratio decidendi of an earlier case to a subsequent case which differs from it in certain essentials. Therefore, it said, the law has to move with times. It cannot be, the judicial function is not merely to apply the precedents, but move forward having regard to the objectives of the Constitution, preamble of the Constitution, directive principles of the Constitution. In the absence of a precedent, the Supreme Court said in Rajagopal Ganguly, the three factors are the three supreme forces which should guide the judiciary is preamble to the Constitution, fundamental rights guaranteed, and directive principles of state policy. And it said very, very interestingly, natural justice is not something that is given to us by Article 14. But Article 14 is only a guardian of natural justice. That is, natural justice was there, has been there, and will have to be there, and will be there, irrespective of Article 14. What the Article 14 does is, it does not by itself give any citizen natural justice, but it acts as a guardian of natural justice. Of course, certain judgments have said that this is the procedure under as per natural justice, but this will apply only for future cases, as if natural justice arises from particular day in the life. No. Rajagopal Ganguly says, natural justice is there always. Article 14 has only provided a guardian of that nature. One of the reasons for why this Rule 9(1) was struck down was that it is opposite to public policy, of course, number one. It is contrary to natural justice. 3, it is a product of unequal bargaining power. 5, it can be discriminatory. 4, it is opposite to good conscience or it is unconscionable, and it is untenable applying the principles of what is right and what is wrong and the constitutional force. Of course, subsequently there have been any number of judgments which followed these principles, but only sad part is that the principles laid down in Rajagopal Ganguly, though they are applicable both for public employment and private employment, particularly because the position of the impugned clause there has been tested and the anvil of contractor, independent of its being instrumentality of state. Unfortunately, the courts have not extended the principle laid down about unconscionability of a contract in Rajagopal Ganguly in subsequent judgments. And it has merely, whether it is a civil court or whether it is a constitutional court, they have been satisfied telling that either it would not apply or you are entitled only for compensation for wrongful termination of the contract without applying Rajagopal Ganguly, even in determination of the compensation amount. I trust that this judgment is applied in more and more areas of protecting employment, because this is judgment which is intended to protect the citizens against economic might of the employees. Thank you very much.
Thank you, sir. The
Thank
one day preparation for a particular topic, like you said, that today only you have taken up the topic and prepared it. So as usual, we will take few questions. For a youngsters to understand, how should he understand the nuance of the entire gist of the judgment? Should he go hurriedly in the first round and thereafter understand second? Or should he try to understand from the head notes? How should he go about it?
Head notes, it is better we reject it because it is editor's view and not judge's view. Head note is written by the editor of the journal and not by the judge. A glorious example is the Ramakrishna versus National Textile Corporation, NTC. In that Ramakrishna, if you see the head note says, insofar as the workmen are concerned, a right which is not specifically denied is deemed to have been granted. That sentence or that philosophy I don't find anywhere in the judgment. But I successfully read the head note and got a decision also in my favor in one case. But subsequently, Supreme Court confirmed that decision on a different reasoning than the reason. Understanding anything in law, forget about the judgment, is only one way. That is read, and read. And every time you read, your mind gives the judgment a different dimension. Or you are able to see the judgment or perceive the judgment in a different dimension than the first reading or the earlier reading. And we had a judge, Trivikram would know. We read normally the conclusion of the judgment. And if you go to SCC online, paragraphs you get in the head notes or in the digest notes is the ultimate conclusions. We read that conclusion paragraph, we extract that conclusion paragraph from website and go to court. Conclusion is always based on two things: facts of the case and applicable rules. These two you can ascertain and assimilate only when you read the judgment in its entirety. See, for example, today I was preparing papers in an arbitration claim. I must have been handling that matter almost for last 1 year in CMP, then in arbitration application for interim measure and all that. One clause that I find in the termination, contract termination letter is, government has granted approval for the proposal of APMC to cancel the contract. Somehow from day one, I was firmly of the view that there was no proposal at all from the APMC to cancel the seeking government's approval. I am not on the question that the government approval was relevant or irrelevant. A statement is made in the termination letter that the cabinet has approved the proposal to terminate the contract in its meeting held on so and so. Then I find after completion of the pleadings, there is no proposal at all. But I had failed to read this one sentence in the termination order that cabinet has approved the proposal. Today, while filing the rejoinder, I noticed there is the approval. Where is the proposal? Approval is there. For somebody to approve, there must be a proposal. The difference between approval and dictation is this. If I propose and you approve, it is approval of my proposal. If you direct me to terminate, it is a dictation and not an approval. You know, in administrative law, dictation and approval are miles apart. One is participative decision making. Another is something that comes from a person who has no authority. Abdication of statutory discretion. See, that particular sentence and absence of proposal, it must have occurred to my mind in 20th or 25th reading of a simple contract. Then we are thinking, now we are talking of understanding the judgment. Judgment has to be read in its entirety. Number one. Number two, when you are reading the old judgments, old means what is new today will become old after 5 years. Judgment would always reflect the current thinking, which is in tune with the current state of the society, current values of the society. When you find a 1956 judgment speaking in a different tone than 2016 judgment, try to rationalize why that difference in approach. What are the societal changes that has occurred? Then only you will be in a position to understand it. For example, now, there is one judgment of some Mukherjee where they said that asking questions to explain circumstances is not mandated. So there was a case of this where Supreme Court said, in disciplinary proceedings rules, there would invariably be a clause where the employee has not examined himself as a witness in his defense. Then inquiry officer shall question him on the circumstances appearing against him in the evidence. Long years ago, Supreme Court taken a view that this is analogous to section 313 of the CRPC. Therefore, not asking questions is not mandatory. Can we repeat it today in the same forum as it was said 50 years ago? Because then 313 itself was in permissive words. Today, 313 is in mandatory words, and 313 courts have held repeatedly. If prejudice caused is established by failure to question the accused on the circumstances appearing against him, then the conviction goes for a toss. Therefore, you should read the judgment fully and keep in back of your mind what were the societal values then, what are the societal values now. This is also one of the statements of law made in the judgment in Rajagopal, that interpretation of law should be a continuous process in tune with the times in which we are interpreting. I can only say there is no shortcut, no head, no. Read the judgment in full. Don't worry, you may mark a wrong paragraph while reading for the first time. Do always marking always by pencil, so that in a second reading, if you find some other paragraph more relevant, you can erase the first one and mark the next one. Pencil and reading, these are the two things. And when you are reading, after all, we are all practicing advocates, we would keep those books for eternity, at least during our lifetime. When you read, mark the appropriate paragraphs by a pencil, so that in midnight on some other day, when you want to quote it next day, when you want to cite it, you will know the paragraphs you will have to refer. It is continuous education, not continuing education. Continuing education has holidays, but continuous education does not. Normally, college teachers are sent during summer vacation for continuing education. Rest of the time, they will be educating the students, whereas advocates have to be on continuous education. Yes, sir.
Yeah, Trikram, any question from your side?
No questions at all, sir. Sir has so elaboratively, so eruditely he has presented that I have no questions. And that's one of the reasons perhaps we don't have in the chat box as well.
So thank you, sir, for sharing your knowledge.
Thank you.
Thank you.
Happy New Year.
Happy New Year in advance, sir, and many thanks. This is the first day of vacation, and you have given us time. That itself is a big Santa's gift, as Mr. Chatrat rightly said.
Thank you, sir.
Thank you, sir. Before we part, tomorrow the session would be the admissibility of forensic evidence in India vis-a-vis the right against self-incrimination. Do stay connected with us tomorrow at 6